All right, we can go off the record. Mr. Chavez, I remember you, and I will tell you what is happening with your face. That has gotten bigger than it was the last time you were here. You need to go see a doctor and have that looked at. You understand?
Yes, Your Honor.
All right, good luck to you.
God bless you. Thank you.
All right, thank you.
Thank you, Your Honor.
You're welcome.
Hours of community service to be completed within 30 days. Okay. Probation is continued.
Your Honor.
Okay. Mr. Ashley, you wrote me a profile. Your profile, why did you do that?
I'm sorry, Your Honor.
You wrote me a copy of your profile. You wrote it longhand, 2.5 pages.
Yes, I did.
Why did you sit down to do that?
When did I sit down to do that?
No, why?
Why? You asked me to.
Why did you do it the way that you did it?
I wasn't sure what a profile was. I looked up the dictionary and it said a short something or other about
The things that you thought were important about your life?
Yeah.
Interesting reading. More than I knew about you before.
I don't know if that's good or bad.
I guess only the future will tell that, so we'll have to wait and see, right? All right, thank you, sir. Information that you're going to provide to the court will be the whole.
Yes, sir.
Want to make sure that you're doing this voluntarily. Has anyone threatened you or forced you to get you to do this?
No, Your Honor.
Has anyone made any promises for you to get you to do this?
No, Your Honor.
Mr. Gonzalez, you were placed on probation by the court. Is that true?
Yes, Your Honor.
And as a matter of fact, you had a prior violation where I had suspended jail time to give you an opportunity to not have to do the full 30 days in jail that I had for it, right?
Yeah, that's correct, Your Honor.
And then I suspended 26 days of the jail time that I had ordered to show that you didn't have to have another violation, but now you have a new violation. Is that true?
Yes, that's correct.
That new violation occurred on September 18th, where you failed to appear for a test, and it looks like you also failed to submit to a PBT on your car on September 15th. Is that true?
Yes, Your Honor.
All right. I find that the defendant has knowingly, intelligently, and voluntarily tendered sufficient factual basis for the court to find him guilty as indicated. Ms. Nichols?
Thank you, Your Honor. I spoke to Mr. Gonzalez this morning and he stated to me that his particular factory is still open. The strike is most likely coming with respect to his work, but his factory is still open. His supervisor expressed some concerns regarding how he's been acting and stress level. And I can say from my conversations with him, he definitely seems to be leaning towards back more of the, more angry Victor as we were talking about it. And I do understand the court did suspend the jail time previously for him not to have a violation. I do have concerns that the continual technical violations resulting in jail time is having more of a mental health toll on Mr. Gonzalez. I would like to ask the court to take that into consideration in using any of the suspended jail time, and I'll let Mr. Gonzalez make your statements he wants to make at this time.
Mr. Gonzalez?
Blow. I missed the blow. I went back the next day and I took a lab and just, you know, it was too early in the morning. I just didn't hear the alarm. I just didn't hear the alarm, and you know, I talked to my supervisor, the plant manager actually had to sit down and talk with him, and he wrote me a letter. I forgot that. So I just, you know, just being unorganized, you know, within myself.
I forgot that there's also a claim that you have failed to provide your AA verifications to part of the violations. That's something that you forgot as well.
No, Your Honor,
You did provide them?
Yes, Your Honor.
Okay, all right.
Just,
Go ahead. I didn't mean to interrupt you. I just thought that there might have been something else that we should.
no, I've been going to AA every day. I set up an appointment with Alex one-on-one. The first meeting was, our first session was last Friday. And you know, I had a good talk with him, and you know, he encouraged me to do some things that I wasn't doing. I mean, that I was doing before, and I'm not doing now. Meaning, like, you know, getting myself inside the gym, and I just been hesitating on that because I got so much going on right now. You know, but it's just things that I got to put in my daily basis. You know, somehow I got to fit that in there. You know, because I know that I become an angrier person uh, due to the fact that, like, if I miss a blow or anything like that, I just get mad within myself. I'm not a good person to be around with. And that happened over the weekend, and my head is got, you know, I don't know what's going to happen. And, you know, here I am. You know, I had one vacation day left. I used all of those up already. So today I do have a vacation, and I used that up already. And so here I am, man. I did want to say this. Like a couple weeks ago, we had just the achievement week at work, and I just got my certificate for 5 years being at Bridgewater for 5 years, and I was happy about that, and you know, but you know, I don't know, I missed that blow, and you know, everything from missing that blow, it brought me down. Um, I just, you know, I'm a type of person that, you know, I don't want to be around anybody when something like that happens, because I just might just a changed person. You know, I'm mad at myself. You know, the alarm is there. I just didn't hear it. You know, I don't get much sleep. It's like, you know, it's been like that for years now. I feel like I'm getting older. I feel like I aged 10 years.
Mr. Gonzalez, I don't need to interrupt you, but you have been doing stellar. You've been doing magnificently until your brother got out of prison. And I don't know if there's a connection, and you and I talked about the guilt and remorse that you had about your brother going to prison and how you may have played a small role in that. And that's why I gave you the break. I gave you the benefit of the doubt to try and help you, because you were already beating yourself up about that and trying to be all these things for your mother and for your brother and all the stuff that you were trying to do too. So I suspended a whole bunch of jail time, but I told you when I did that, you had earned the right to go to jail, and that you're going to end up going to jail. You're probably going to lose your job because of that. So I don't believe that this is going to necessarily keep you back. I just think it's going to knock you off center because you're not really balanced right now. You're not really balanced because you're not taking care of yourself. And I was talking about your skin the other day too, about how that's showing that, you know, your nerves are frazzled and that you're not taking care of yourself. you were going to the gym, you were looking good, you were in good spirits, and all of that seemed to unravel. So I want you to take care of Victor because you're not taking care of yourself. And losing your job and having you have to start over from scratch is what it's going to take for you to take care of yourself. It's a tough pill to swallow, but let's be done with this. Let's get you back where you were. That's hard to hear because you probably feel like you failed on some levels, and maybe this is not the way that you wanted to see things happen. But I'm at the end of my rope. I don't want to kick you out of the program, but I'm at the end of my rope. So 30 days jail and probation is continued. No early release or release from tether without further order of the court. I want to bring you back to talk to you because I want to make sure that you understand that I'm serious when I say I'm not giving up on you. So we'll come back, we'll have some more conversations. I'm not going to wait 30 days to see you. I'm not going to wait more than a week to see you. But I need you to get back to who you were, and only you can do this. And you can't do this. We're here to help you, but we can't do it for you. You got to do this. And you have the ability to do it. You've seen it done. You've seen your son do it. So you can do this. But you gotta start focusing on you and not these other things that are around you. Okay?
When you say, Yana, when you say you want to come see me, what were you talking
No,
about?
I'm bringing you back here to see me here. So when we have a session of court, you can still sit in the session of court and see what's going on. Still talk.
Stay.
No. So every week when I have another session, I'm likely to bring you back until you're released.
Is there any way I can,
No,
let my
no.
job know?
Well, you can ask Mr. Avon if you can use the phone. I'm sure he'll let you. But I can't save the job for you. I track that. How many times have I actually suspended jail time for you?
Twice.
Yeah.
And
then I rearrange for you to go to jail on weekends and stuff like that, which is something I usually don't do. I'm at the end of my rope at this point. Yes, Mr. Gonzalez, you just have to be focused. I just said a moment ago, you've seen your son before.
Yes, Your Honor. I feel like that I am doing it. I had when I came in this program, there was a whole bunch that needs to be fixing with me.
And you had done that.
Yeah.
You actually got your delayed sentence, remember?
Yes, I remember that. Yeah. And I I think the most important thing that I got from the sobriety court program is that, which is the best thing. I'm sober, and I finally realized that I surrendered, and I finally figured it out. Like, this is not the way of life. Way of life is, I just have a lot of other issues, unorganized, and amongst other things with family. It's a lot of things that you may not know about, that I deal with. There's just a lot of issues that I'm dealing with right now, and I'm not trying to, but I just think, by losing my job, I mean, it definitely won't help, Your Honor. I know it won't.
All right. I've made my ruling, okay?
William Joseph Bankson, 234918 OD, Mr. Bengtson appears here today with his attorney, Robert Percola. The city does not appear of their own choosing. We were set for a sentencing. In respect to the matter, it says that the probation department has indicated that the assessment is not done yet. Is that right?
It's done. We just do not have the report. He had the substance abuse assessment done on the 18th with his counselor, Cheryl Welch.
Okay.
He's in counseling, as the court may know from the other file. So I don't know if it's the type of case, given those circumstances, the court would feel comfortable proceeding without it. And then when it does get here, just having him follow the recommendations in there. Again, he's already actively engaged in counseling and working towards those obligations already.
I want to see it, given all of the other circumstances that were attendant with this, with the other case and whatnot. And I remember having a discussion about the psych eval and whether or not it was going to be done in-house, if she could do it.
Mr. Bengtson has scheduled that. I believe it's going to take place in Marinette. Is that right, Bill?
Now I had somebody helping me out, made the phone call for me. They called up Marinette and they said they don't do court ordered. They don't do court ordered.
What about your Dr. Welch? Did you talk to her about it? If she could do it?
She's the one that
Recommended it.
One that recommended it.
Right, that's where I got it from.
Gave me a name. You know, she even gave me a name of that down there, and I was good with that because it's going to take 3 sessions or something like that. But then I got to redo it and find out. There's no psychiatrist.
Can you send them down to probation to have a talk with them about this issue? I'm not quite sure what's going on here, but there's it all generated from Dr. Welch's recommendation. So
yeah, and then the court's order in the last sentencing included getting a psychological evaluation within some specified period of time. And then he was working with Dr. Welch, who recommended someone in Marinette, whom, if I'm remembering correctly, Bill, you contacted, but then they told you that they don't do that particular type of thing once
court order.
Yeah, if it's court order.
Psych evaluations is what they said. They don't do court order.
That sounds like they may be just confused about what's being asked for there. So that could probably be clarified.
all right, good. I think so too, Mr. Percola. We're not asking for a multi-phase, whatever, MM3. So, all right. So we're going to continue this briefly then. What's Mr. Percola's next regular round date?
October 12th.
Will that work, Mr. Percola?
For me, it does. Is that okay, Mr. Bengtson?
October 12th, 9 a.m.
What's going on the 12th?
Well, we're asking you. I have to adjourn it so I can get your report. It didn't come in yet.
Oh, yeah. Well, I took it. I took the 3-page test thing.
Well, we need the results. It needs to go to probation and it needs to be incorporated into this report. So follow up. We're going to set it over to October 12th at 9 a.m. Okay?
So I gotta come back.
Yes. Yes, we'll give it to you in writing. Make sure that they get the report from where you had it done.
Okay.
And follow up on that psych eval issue.
Yeah. Yes, ma'am.
All right, then. In the meantime, your bond terms remain in place. Any questions?
No.
All right, thank you. Have a good day.
Okay, thank you, ma'am.
Thank you.
Yeah, I got it.
All right, Mr. Bradley, you can come forward. Good morning.
Morning.
Got your mom and dad with you this morning? Yes, good morning. You can stand right at the podium there if you wish. If you would, I should say. All right, we'll call the matter of the People versus Colin Bradley, 237403 SD. Record should reflect Mr. Bradley is here in court, as well as his attorney, Robert Percola. Prosecution is not here of their own choosing.
Yeah, okay. Thank you.
In regard to the matter then, did you have a chance to go over the pre-sentence report with Mr. Bradley, Mr. Percola?
Yes, I did, Your Honor.
Is there anything of a factual nature that appears inaccurate?
No, Your Honor.
Anything you'd like to say on behalf of Mr. Bradley before the court imposes sentence?
Yes, Your Honor. Mr. Bradley is a young man who, since he hired me in this matter, he's been focused on, okay, what can we do to get a handle on the alcohol problem? He, went out and got a substance abuse assessment very early. He tried to start in on doing some sessions, but unfortunately wasn't able to get that. But it is his plan to follow through with the recommendations here in terms of the outpatient counseling and the smart recovery. I think those are things that will help him get on track in dealing with his substance abuse issues. The sober link as well will be something that will allow him to show the court his ability to toe the mark. And if he can't, it'll become painfully obvious with these type of interventions in place. But he's a young man. He's, in one of those situations that I always think, he's at the fork in the road of life, and you can choose to continue to use and abuse alcohol when it's caused you this many problems in your life already, or you can reassess and make different plans about how to go forward. That choice will always be Mr. Bradley's, but I'm confident that he, with the support that he has in his life and the tools that he'll get from outpatient and the smart recovery, that he'll be able to make a good choice and go forward and live the kind of life that he's capable of. He's got a good job, and he's got everything in the makings of having a successful life. It's just him choosing day in, day out to seek that out and not the opposite.
All right.
Again,
go ahead.
These type of situations where, you're drinking and driving in the literal sense, you're always in a position where your life is just hanging by a thread. You don't quite realize it perhaps, but that's the case. Other people's lives, each person you zip past on the highway, their life is hanging from that same thread. But the more reminders of how Mr. Bradley slipped that noose on this night, are important for him to keep in the forefront of his mind when making his next decision. So, I leave anything to say else for Mr. Bradley. Generally a man of few words, but if he has anything he'd like to say, I think he'd like to express it.
All right. Mr. Bradley, anything you'd like to add?
No, Your Honor.
All right. So you live with your mom and dad, is that right?
No.
No? Okay. This is your second one. You're 21 years old.
Yeah.
How's it feel? Do you have driving privilege at all?
Not right now, no.
No. So you have a minimum of a 1-year revocation, right?
Yeah.
When are you eligible to have a reinstatement?
September 9th.
Of next year?
Yep.
So how are you getting back and forth to work?
I got a couple of buddies that work with me actually on the same shift that pick me up, drop me off.
All right. How do you get your groceries?
That I don't really know yet.
Mm-hmm. So look at those people behind you, and you think you're causing any kind of grief in their life by your behavior?
I know I am.
Yes. On so many levels that are yet to even be discovered. You know how much money you're going to have to pay for somebody to deliver your groceries? And or beg your mom and dad to take you to the grocery store?
Well, they live 2 hours away.
Oh, they do? Worse yet.
Yeah.
Worse yet. And where do your parents live?
Marquette.
Marquette. Okay, so that's where you got your first one, right?
Mm-hmm.
Yes?
Yes.
So what's it going to take? You're 21 years old. You've got your whole life ahead of you. Do you want to have a 5-year revocation along with a significant sit in jail on a felony?
No.
No, I wouldn't even, I'm surprised you even hesitated on that. Because that's what's next. You know that, right? Mr. Percola's gone over that with you, no doubt. So it's time to make some changes. You're gonna have to make better choices.
Yeah.
I think you're probably, are you what would be called a binge drinker, meaning you like to party when you party, but you don't party every day?
Yeah, I guess.
Well, they said you have a moderate level of substance abuse disorder already at 21. That's what your assessment says. You're not mild anymore. You're not severe, but you're in the moderate land. You're moving on up in the world and not in a good way with that, right? Did you read your substance abuse assessment?
I honestly haven't seen it, no.
Well, I would suggest you do so because they tell you a lot of things about you may not be realizing.
Yeah.
So based on all of the tools available to them, you have graduated from mild to a moderate substance abuse disorder at 21. So it's time to make some changes. You can do it. You're young enough. You're smart enough. You're obviously a hard worker. You got a lot going for you. You've got a good job. So let's not, blow it. It's time to nip this in the bud now and make some better choices. One, there's no reason that you can't live without alcohol. I mean, it just really is not anybody's friend, and you make poor choices on it, obviously. You're right. Your attorney's 100% right. How would you feel if you had to get up and put one foot in front of the other every day, knowing you had eliminated a whole family from the face of the earth because you just made a stupid decision to drink and drive?
Not good.
No, it would change you completely. It would devastate you. So those are the kinds of things you have to keep circulating in your brain. Right now you're on probation. You can't drink, but let's fast forward 3 years from now. The pain and suffering of this incident is going to start to fade in the rearview mirror of life, but you can't let it do that. You have to keep tools in hand to make you understand that you cannot be making bad choices like that. Hopefully you'll make a choice never to live with alcohol. If we can't stop you from doing that, we need to stop you from making the choice to drink and drive. Okay, period. Because that's where you're standing. You're going to jump right on over that big cliff down into an abyss that makes it really hard to crawl out of. So use this as a tool. You haven't done anything now that you can't get past in your life, but you have to stop this behavior now. All right? All right. I think that the recommendations are appropriate. I will follow them. I think that a brief term of probation is important. Although he has been convicted on a first offense, this is actually his second one in the last couple of years. And he needs some oversight. 9 months, $300 oversight fee. Fines and costs on count 1 are $590. On the open and talks in the vehicle, $340. Were you privately retained?
Yes, sir.
All right, so no assessment for attorney fees. $75 prosecutor's fee, $100 in restitution, Kingsford Public Safety Department, $75 to the crime fund fee. There are 2 justice system assessment fees to the state of Michigan, each in the amount of $50. That's $1,580. How is he choosing to pay that off?
You can see he has $50 he can pay today and $50 a month. Hopefully you can devote more towards that as money becomes available, but that was his proposal, Your Honor.
It says here you have income of $2,600 and expenses of $1,900. Why can you only make $50 a month?
Just to be safe for now.
What are your monthly expenses?
Rent,
How much?
800.
Do you live alone?
Yep.
Yes.
Yes.
And does that include utilities?
Everything except for electric.
And how much is that?
Electric ranges from 30 to 60 bucks a month.
All right.
And then food, which is probably like $300-400 a month, I'd say.
So how, are you working full time?
Yeah.
And how much an hour do you earn?
21.80 something. exact number up there.
All right, so I've got you at roughly 2,800 net after taxes based on that income. So right now we've accounted for 1,250. Do you have a car payment, phone payment, stuff like that, or not?
Yeah,
Phone, how much is that roughly?
about $50 a month.
What other expenses do you have? Gas for your vehicle? Huh?
I'm gas anymore.
No, I suppose.
Um,
No car insurance? Huh?
Wi-Fi.
Mm-hmm. It looks like you should be able to at least make a minimum of $100.
I feel it coming.
Was it the date nighter, Judge?
Maybe so. You know, I have to get my at least, I'm a sleeper. I need at least 10 hours. And I didn't get that last night. All right. Yes. You know, well, you know, my mom would always tell me, Stephanie, you're going to sleep when we were growing up, you're going to sleep your life away. Because you know how young children get up at 6 a.m. and 5 a.m. on the weekend?
Yeah.
I would never do that. It was just like, let me sleep. My mom was like, no, you need to eat breakfast. And I would say, I don't need any breakfast. Please don't wake me up.
I love that for you. I love that.
Oh, no, I can get my sleep. All right, Mr. Griffin, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense of terroristic threat? That's a Class B misdemeanor. The range of punishment is up to a $2,000 fine and up to 180 days in the Bexar County Jail.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 180 days in the Bexar County Jail and up to a $2,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Absolutely, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Griffin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on terroristic threat. They are asking for a $0 fine. They're recommending deferred adjudication in the anger management course. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision, there be a TAP evaluation, 60 hours of community service restitution, and no contact with Kevin Chase II. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense of terroristic threat as a Class B misdemeanor, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. The state offers State's Exhibit 1 and its attachments.
Any objections?
No objection, Your Honor.
All right, and state, is the complainant aware of this agreement?
The complainant is not aware of this agreement specifically because we've been unable to reach the complainant over the past couple days, but the complainant did say for us to use our discretion and handle the case as we see fit.
All right, thank you. You may continue to confer.
Yes, Your
Mr. Griffin, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, Mr. Griffin, how many children do you have?
I have 5.
All right. And are they all with the person who's in the,
No, it's 4 with her and 1 with
and what are their ages?
15, 13, 9, and 7.
Okay, that's only 4 children.
That's with
Oh, okay. And the other one, how old is that one?
6.
All right. Are you employed?
Yes, ma'am.
What do you do?
I work at IFCO warehouse.
Okay. All right. If you're drug tested today, what are the results going to be
Positive
for?
marijuana.
All right. You're going to have to stop smoking marijuana. It's not allowed while you're on probation. You understand?
Yes, ma'am.
All right. This is what the court will do. The court will sentence you to 1 year deferred adjudication, 60 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, the 60 hours will be deemed satisfied. There's to be regular reporting by Zoom or in person. I'm going to want him tested for levels. Those levels need to start going down. You understand?
Yes, ma'am.
Probation, you can just do 1 field visit to see how everything is. If everything is fine, you can discontinue field visits or continue them as you see fit. Proof of employment within 30 days. No employment as a home health care provider with minors. Anger management. Probation, is there anything else? Yeah, we rarely do misdemeanor cases up here, right? All right, is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Griffin,
Yes, ma'am.
here's the thing. When people have children and they were previously married and that person moves on and they marry someone else and you don't appreciate the way someone's being disciplined, in this case, the taking away of the phone and the PlayStation, just because the stepfather takes that away as punishment, your answer should have been, let me call the child's mother to see why the PlayStation and phone were taken away. I know about people who are from split households or they divorced. Usually the issues that would come up on the civil side is you have someone who's not the child's parent doing physical discipline. This wasn't even a case of somebody doing physical discipline. This was a case of somebody taking away a phone and taking away a PlayStation. And what you should have done was ask your son, why did they take away the phone? Why did they take away the PlayStation? And whether you think that the taking away of the phone or the PlayStation doesn't fit the actions that your son took, the thing is, don't rush over the house. Time when that's said, the thing is to take some deep breaths, call the mother and say, hey, my son called me. He said you all took away his phone and PlayStation. Why are you taking away the phone and PlayStation? Honestly, I don't understand why children have phones, but that's neither here nor there. We didn't have them growing up because they were not invented. If you wanted to call your parent because of discipline, you had to walk down the block and find a pay phone, put your quarter in, or either you had to sneak and find a phone in the house to do it. And there were no phones in bedrooms, at least for children when I was growing up. But so that's the proper thing to do, not to go over there and get upset. You understand?
Yes, ma'am.
You're going to have to learn to co-parent. Now, if somebody's disciplining your child physically, you and her need to talk about that. You understand?
Yes, ma'am.
All right. Good luck to you.
Thank you.
Thank you, Judge.
Oh, it's fine. All right. And I know I said you'll take you next, but Mr. Cabanas has been waiting. Mr. Cabanas?
Yes, sir.
Alexander Williams? All right, Mr. Williams, if you'll come up, please. Oh, no. I have the file. All right, Mr. Williams, your case that you were here scheduled for trial on has been dismissed. All right, so now we have this case that is left. And have you been able to confer with the state on this case?
Yes, Your Honor, we have.
All right, and so where are we?
I made an offer, Your Honor, because previously I don't believe an offer was made except for through the Agasol. So I have made an offer today. I don't believe they're accepting that offer since they haven't came back.
All right. So as you know, state has just finished with the murder trial and family violence, they're up for trial. So I can bring you back as soon as possible for a trial on your case, but I can tell you it's not going to be today because we have other cases with family violence that are old, that is older than yours. All right. And defense, if you want to file a motion for a bond reduction, you're more than welcome, of course, to do that. And it can be referred to Judge Nahara. Norma, what's the soonest we can get this on trial? State, how long do you think this trial will last?
It shouldn't take that long. There's just some outstanding DNA that I'm looking into with the lab right now. And I haven't got an answer back with that yet. So I can't give you a definitive answer, but it shouldn't be that long of a trial.
Okay, so then we need to see about this DNA. And how long do you think the DNA will take?
If it's been done, no time at all.
Okay,
But I would have to disclose that obviously to defense. So they would require those 20 to 30 days, I'm assuming, but I'd have to just determine whether the items that were, again, in our case, have been sent over or not. And I just actually trying to review that currently.
all right, so this is what we'll do. I'll put you down for the earliest trial date that we have, with the caveat that if you still haven't received your DNA, and if DNA is something that the state needs for their case, then we're going to have to continue it. If it's something the state doesn't need for their case in defense, you don't need it, then we can go forward if everybody agrees to go forward. Do you understand, sir? All right, Ms. Ferguson, what's the earliest date? Mhm. Okay. Okay. Oh, no problem. Yes. All right, everyone, make sure you keep your voices down, please. Court is calling 2020 CR 2517, State of Texas versus Humberto Chavez, Can I have parties announced for the record for the state?
Jason Gearhan, Your Honor.
Defense?
Adrian Bettis.
And are you Mr. Chavez?
I am, Your Honor.
All right, I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor, I did.
Are you the same Humberto Chavez who was placed on community supervision in 2022 CR 2517 for the offense of possession of a controlled substance, penalty group 1 less than? All right, does anyone want to make a oral motion to the motion to revoke?
Yes, Your Honor, oral motion to change the verbiage states possession of controlled substance penalty group 1 less than 1. It says group, we're asking for less than 1 gram. No objections.
All right. So are you the same? All right. Are you the same Humberto Chavez who was placed on community supervision in 2022 CR 2517 for the offense of possession of a controlled substance penalty group 1 less than 1 gram on June 6, 2023 for a term of 3 years? Is that you?
Yes, Your Honor, it is.
All right, state.
Yes, Your Honor. Violated condition number 1 on or about the 25th day of August 2023 in Bexar County, Texas. The defendant, Humberto Chavez, committed the offense of evade, arrest, or detention in violation condition number 1.
How do you plead to that? True or not true?
True, Your Honor. Your Honor, we'll waive the remaining violated conditions.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to $1,000 fine?
I understand, Your Honor.
I'm sorry, everyone, just one moment. Can you mute us, please? Number 1,
Yes, Your Honor.
court will find violation of condition number 1 true. Is there an agreement?
There is, Your Honor.
And what is the agreement?
The agreement is to adjudicate guilt, to revoke the individual office probation, sentence him to 180 days in the Bexar County, I'm sorry, not the Bexar County, the state jail facility. And also the state will take into consideration the 2 new number 1s, clause numbers 715.
Everyone, please whisper.
715-748 and 715-749. Your Honor.
All right. Is that the agreement?
Yes, Your Honor.
Mr. Chavez, are you asking the court to follow that agreement?
I am, Your Honor.
Are you waiving your right to appeal?
I am, Your Honor.
All right. The court will follow your agreement, sentence you to 1 year in the state jail facility, give you credit for any time served, take in consideration 715-748 and 715-749.
Your Honor, our agreement was for 180 days.
Oh, I'm so sorry.
That is.
Yeah, I was just seeing if people were paying attention. All right, I'll follow your agreement to 180 days in the state jail facility. Mr. Chavez, you do have, it appears that you have a drug or alcohol problem. If you would like, I could refer you to the therapeutic community. Whether they place you in the program or not is completely up to them. I don't have any jurisdiction over that. However, if you were placed in the therapeutic community, it will not extend your 180 days. So would you prefer that or no?
No, Your Honor, actually, I'd like to just be done with.
All right. So here's the thing. If you don't get your life together, you're going to be back right here with another drug case. Do you understand?
I understand, Your Honor.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
I did, Your Honor.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I do, Your Honor.
All right, we can go off the record. Mr. Chavez, I remember you, and I will tell you what is happening with your face. That has gotten bigger than it was the last time you were here. You need to go see a doctor and have that looked at. You understand?
Yes, Your Honor.
All right, good luck to you.
God bless you. Thank you.
All right, thank you.
Thank you, Your Honor.
You're welcome. Elsa Morales. Are we here for sentencing?
Yeah, Judge, we're here for sentencing. You see at the fifth case, there's life of probation. There's one letter of support, I would like to submit support from her daughter.
Okay. All right. Who is the prosecutor on this case? They know. Yeah. All right. Court is calling 2023 CR 5382B. I'm sorry, what? Hi. There's a lot happening. So everyone, this is what we're going to do. When we're on the record, don't approach the court coordinator because they're too close. If you want to approach the deputy and have them bring your person out, you're more than welcome to do so. Court is calling 2023 CR 5382B, State of Texas versus Elsa Morales. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Glenn Payne for defense.
And are you Miss Morales?
Yes, Your Honor.
All right, you entered a plea on August 14th. You entered a plea of guilty, applied for deferred adjudication. The state is asking that your punishment be assessed at 1 year in the state jail facility. They're remaining silent on your recommendations and they're taking certain cases into consideration. Have both parties had a chance to review the PSI report?
Yeah, there actually wasn't a PSI created in this court. You asked to reset. We asked for the PSI to get the letter, then you just wanted to see the criminal history.
Yes. So is there criminal history available for the court? Thank you. Okay. All right, the court has reviewed the criminal history. Defense, do you have any witnesses?
Judge, no witnesses. Like I said, we just have one support letter on behalf of Ms. Morales. It's her daughter, stating how she helped, that Ms. Morales helps take care of children, and she was working at a home health care, also supplied money for the family. We're going to ask that the court grant her probation in this case, and let her continue support of her family.
All right, Ms. Morales, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Elsa Mireles.
All right, why are you stealing?
That was a bad choice. I wasn't thinking.
Why are you involving a child in theft? Because it says that this was the MO, go to the store, put things in a cart, and then have a child push the cart outside. So you're basically unwittingly making a child a criminal. Why are you doing that? I mean, your attorney was not there, so he can't answer this question. You did it. You took a child in Target, or as we say, Target. You took a child there, loaded things in a basket, and for that child to know to just push that cart towards all points of sale tells me that somebody told that child, this is what's going to go down. We're going to go in, we're going to put items in this cart, and you just keep pushing it. So why?
I have no words for that.
Yes. And how old was the child that you all involved in your criminal activity who now thinks it's okay to engage in criminal activity?
5 years old.
All right. So you took a 5-year-old. And what day of the week was this? Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, what day?
I'm not sure.
Right. Was it a school day?
No, I'm not too sure.
All right, so you take this 5-year-old, walk me through it. So the 5-year-old is pushing the cart out, and obviously police are called, right?
Right.
And did they speak to the 5-year-old? What is the 5-year-old thinking? Do you know? I know somebody will probably object to speculation, but I just want to know, what was the 5-year-old doing when police are there? I'm assuming you all were placed in handcuffs.
I was already in the car. It was with his mother.
Mhm. All right, so it was you and his mother who was stealing. Is that what you're saying?
We were already out and the mom told him to leave it there and he did it.
I'm sorry, I can't hear you.
Somebody else helped the little boy push it out.
All right, so someone helped the little boy push the cart out after you all were committing a theft from Target. And what items were you all taking?
It was stuff for the kids.
No. Don't put this on the children. What items were you taking?
Toys.
And what else?
It was clothing.
So you're teaching children that in order to get things, they should steal. That's what you're teaching. And you left out to the tune of $553.69. So how full was the cart that you were taking out?
It was full.
All right. And then now I've received this letter where you took a child to help you steal, and somebody is saying that you're taking care of children and you're a home health care provider. I don't allow people in this courtroom who are on probation to be home health care providers. And who are you providing health to? Is this a relative?
No.
Right. So I don't know how you're able to take care of children and be a home health care provider.
Those are my kids that I take care of.
Mhm. I don't think you're a good candidate for probation because it appears that your background is littered with theft cases and you're here on a theft enhanced. And how old are you?
43.
I mean, you're old enough to know better. It's not like you're 20 or you're 19 and you have peer pressure. So again, tell me, why are you stealing? It says here that you have a job, that you can pay for things. I don't understand the stealing.
Your Honor, but that doesn't excuse for it.
I'm sorry, what?
I didn't have a job at that time, but that doesn't excuse for it.
And it certainly doesn't excuse involving a 5-year-old in your criminal activity. So again, why should I give you probation? The state is silent. Why should I give you probation?
Because I gotta take care of my kids. There's no fathers involved for my children.
Well, when you were using the 5-year-old to steal items, were you thinking about, who's going to take care of my children if I am at the Bexar County Jail? Were you thinking about that?
No, Your Honor.
And if something would have ended up happening, sometimes when people go to places and they steal, sometimes people end up getting shot. If that 5-year-old would have been shot, you know what would have ended up happening? You would have been on somebody's news, boo-hooing and crying about how it's unfair that your child was shot. So what am I supposed to do about this? You won't stop stealing.
I will, Your Honor.
Now, did you say that to the last judge, that you were going to stop stealing? How many times in your lifetime on this planet, as a 41-year-old, have you had criminal cases for stealing? Now, mind you, name them all because I've read the report.
Like, I believe 5 cases.
And you have not learned anything from that. What you've learned, obviously, is to continue to steal and start this idea where you take a child in with you, you put items in a cart and you just have them pushing it out. In my mind, I can imagine this 5-year-old, because when you see children pushing carts, they're not even old enough to stand and look over the cart. They're just struggling, barely pushing it. And I'm always thinking to myself, why doesn't a parent help that child push their cart?
Your Honor, we told him to leave it there and he continued pushing it out. That's when the other 2 people helped him.
Oh, so now you're saying
Yeah, that's what we did.
you did not include him in your criminal enterprise.
We told him to leave it there and the other two people, random people, helped him.
Oh, so this is not a theft case. You were not intending to have him steal. Is that what you're telling the court?
That's what happened.
No. Are you telling the court that this was not a criminal enterprise, that you or somebody loaded a cart at Target with items, the 5-year-old was pushing it, and you're continuing putting items in a cart totaling over $500, and then as he's pushing the cart past points of sale, you're telling him, oh, just leave that there. Maybe you're telling him, we don't have money for that. We just loaded up the cart for some unknown reason and we have no money for that. Is that what you're telling the court? If not, let me know. I mean, I wasn't there. State wasn't there. Your counsel wasn't there. I'm just trying to figure out if that's what you're telling me. If that's not what you're telling me, say, Judge, no, that's not what I'm telling you. I'm not going to take that as a sign of disrespect, okay? So, are you telling the court that you all loaded up a cart of items at Target, the 5-year-old is pushing the cart, and you're telling the 5-year-old, leave the cart there, we don't have any money for these items, and your intent was just to walk out? Is that what you're telling the court?
To walk out without the stuff, like to leave the stuff there.
Okay. Is there anything else?
Judge, with this testimony elicited from my client at this time, I think we need to ask the court to withdraw her plea.
All right, that'll be denied. All right, this is what the court is going to do. Court is going to find you guilty. Court is going to sentence you to 1 year in the state jail facility. Give you credit for any time served. Take in consideration GJ 812055, JN number 2127782. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Good luck to you. Do not steal. Do not take what does not belong to you, and do not involve children in your enterprise.
On behalf of Devon Thompson, Mr. Thompson, please state your name.
Devon Thompson.
Who's this? I met her the other day. Oh, okay, I just didn't recognize her. All right. Good morning. All right, what are we doing?
We'd like to ask to set the preliminary examination and address bond.
You may address bond briefly. Preliminary examination will be set October 3rd, 2023, 9 a.m. That'll be in person before Judge Barr.
Thank you, Your Honor. We would like to ask for a bond reduction. Your Honor, my client is concerned about getting back to work. He would like to prioritize supporting himself, supporting his children, and paying his rent. He maintains a home on Forest Avenue and would like to stay there. He is very confident that he can comply with any bond terms set, not to go near the complaining witness. So we would just ask if you would let him post 10% of a $10,000 bond or any bond reduction, really.
Response.
Your Honor, we would ask that bond remain the same. In this case, the victim went to his house to retrieve her belongings. She ended up taking a nap thinking he would be home for a while, and she was awoken by him on top of her, strangling her. While he was strangling her, he was demanding the password to her cell phone. She gave him the code to stop him from strangling her. He read her phone, became upset again, and then began to assault her again. He threw her against the wall multiple times, slammed her head onto the floor, kicked her in the face while she was on the ground. She tried to leave, but he would block her and refused to let her leave. She eventually escaped through a window and ran to try and get help. And we also would ask for a condition of bond be added as well, that there be a no-go to her work. And we also had a report from the victim that his family is harassing her in person and on social media as well.
That his family is?
Yes, Your Honor.
Any additional response?
I would just like to say my client denies that these events happened as stated, and I just ask for that bond reduction. I understand the charges are serious, but he is denying them at this time.
Motion for bond reduction is denied. Prosecutor, if you send over the order adding that condition, the court will sign it regarding work.
Your Honor.
All right, thank you.